Good afternoon, everyone, and welcome to this third and final webinar in our series of 3 special webinars, helping Southeastern schools through the Family Law Maze. My name is Karen Akers, Project Officer for South Coast Family Law Pathways Network, and on behalf of the Network Steering Committee and our project partners at the University of Wollongong and Department of Education and Communities, we'd like to thank you again for joining us in this webinar, which was made possible by the University of Wollongong Community Engagement Grant Scheme. I'd especially like to welcome some Aboriginal participants from schools across the South Coast and invite Michelle Watzaka from Anglicare to formally extend that welcome.
Hi everyone. Firstly, I'd just like to say that I'm an Aboriginal woman, born and raised in Sydney, with family links to the South Coast. I'd like to acknowledge the traditional owners of the lands that we're all meeting on here today, and pay our respects to elders past and present and other Aboriginal peoples who are part of this webinar. Thanks.
Thanks, Michelle. Once again, please note the slide on your screen regarding technical matters and type a message into Laura read back in the chat box if you need any help with technical matters. And just a reminder to let us know which school you are and how many people are in your group via chat if you haven't done so yet. Thanks. We have a diverse range of experts on the panel today. Joining us for this webinar at the moment is John Littrich, Associate Dean, Faculty of Law, Wollongong Uni. You there, John?
Yep, I am. Hello, everyone.
Greg Hand, Student Support Coordinator, Student Counselling and Welfare, Illawarra, South East Region, Department of Education and Communities.
Hello, Karen. Hello, everybody.
Wayne Freakley, Chief Legal Officer, Legal Services Branch, Department of Education and Communities in Sydney. You there, Wayne?
Hi, Karen. Hello, everybody else.
And with me right now from our Family Relationship Centre is Carolyn Bateman, Senior Family Dispute Resolution Practitioner. She's standing in for Jenny Bailey, who is a child consultant and family dispute resolution practitioner here, has had a last-minute family emergency. So thanks to Carolyn for doing that for us. And Michelle Watzaka, Program Manager, Family Services and Post-Separation Cooperative Parenting. They're all available to take your questions at the close of the seminar, so please feel free to type in your questions as we go and we'll address them at the end. Our first presenters today are Carolyn standing in for Jenny and Greg Hand. Jenny, as I mentioned earlier, is a specialist child counsellor with many with children from separating families. A number of therapeutic programs locally via the FRC. She's highly qualified to share her experience of children working with children in family separation, and she's happy to take your questions perhaps after this webinar at some point when she's back in the office. You can contact her through the FRC. But welcome, Carolyn, who's standing in for Jenny, and she's just going to give us a brief child wellbeing.
Okay. Good afternoon, everyone. Get to hear my voice again after last week. So I'm going to be talking about the children's work that we do at the Family Relationship Centre today. Basically, what the children's work is about is bringing the voice of the child into trying to work out arrangements. And also as parents, so if you can talk to parents about appropriate decision making and development. Particularly put a focus on the separation and ongoing conflict can affect children at school. And we ask parents to talk to the teachers about any feedback the teachers are seeing about the children as well. Are the children, firstly, are their behaviour, different behaviours that are being noticed? Is the child tired, maybe from all the different, the changeover arrangements? And also, if there's mid-week changeover arrangements happening, are children leaving things at one place rather than another, at one parent and not being able to collect it? One of the things that we often hear from children is that they would rather go to school and get in trouble for not having their homework than tell one parent that they left the homework at the other parent, because that will bring on conflict. So children can be very, very much in the middle of this, of the conflict. So in the work that we do with parents, we're very much trying to encourage them to focus on the child and how to lessen those types of arrangements from impacting on school. The other thing is sometimes if children are only getting to see a parent on weekends, the parent may try to cram a whole heap of activities into that weekend, and so children can present at school very tired from that time. We try very much to work in a holistic approach, working with the family, working with the community and working with the school. So we'll encourage parents to, both parents to contact the school, to try to attend parent-teacher interviews. If they can't do it together, then to talk to teachers separately. But always we're saying to parents, the conflict must be kept away from the child at school. So how can schools assist? School is a normalising place for children. It's their social place, and it should be conflict-free from their parents. I mean, we all know about the conflict the kids will create for themselves in the playground. There's school counsellors that the children can be referred to, and school also offers that routine that is normal for children. And it can quite often be their safe place away from the conflict of the parents. Jenny is able to take referrals from schools if you're thinking that there's a family that needs further counselling, pardon me. So Jenny can work with children individually. She'll work fairly short term, but she can also, as I said, work with the parents. She runs therapeutic groups for children in separation, but also if there's enough children presenting with a particular need, she can run a group for them. So, for instance, we ran a group for 8 to 10-year-old boys over the Christmas holidays that focused on anger management and self-esteem issues. So if I can encourage you, if you have any questions, please either put them forward now on the screen, or you can contact Nowra Family Relationship Centre and book a time to speak with Jenny if you'd like to know more information. Thank you.
Thanks, Carolyn, for that. And yes, I was just going to remind people that they can contact Jenny for information about those groups and therapeutic options at any time. Michelle Wasaka is the Manager of Post-Separation Cooperative Parenting Program and our go-to person for Aboriginal post-separation services in the region. I think we have a photo of Jenny somewhere. Sorry, Michelle, somewhere. She's going to say a few words about family law, Aboriginal families and schools. That's to you, Michelle.
Okay. Hi, everyone. So about a psycho-educational group for parents that we run called Our Children that was developed by Jackie Leonard at the FRC. We deliver that as two 2-hour workshops that are directed towards helping parents recognise their child's needs and how to care for them in their new circumstances. So these workshops aim to provide help for separated parents in conflict and provide tools for more effective communication with their child's other parent around a parenting arrangement. So we hold these groups evening and day in Nowra, and we also have them day sessions in Bega and Maria, and from time to time we can do one-on-one as well. So they're a good thing that you could refer families to if you find that they're not actually going maybe through the Family Relationship Centre, but that you know there are issues around separation. So, and we also provide individual counselling support for the parents. So when we were looking at our post-separation cooperative parenting program, we saw that there was a need for an Aboriginal version of Our Children to be developed. And so at the time that we were considering this, we came across some training for an Aboriginal-specific seminar that was called Aboriginal Building Connections. So Sue Cutmore from here and Terry Grant, a counsellor, Michelle Polash, who is our worker in Maria, and Nerida Oberg and myself completed this training that's specifically designed for Aboriginal parents, carers and grandparents. So it was developed by Interrelate. It was piloted in a number of Aboriginal communities around Australia, and was very much that Aboriginal version that we were looking for. So it presents a more culturally appropriate workshop for Aboriginal families around that family law sort of stuff and that discussion. It aims to support parents, grandparents, carers, family members to practice positive ways of parenting after separation. So we will actually be piloting this with through the Kulanguddy Aboriginal Child and Family Centre in Nowra in Term 3 to separated families, and we're hoping to run these in Bella and possibly Bega. So we've also got another practitioner, Michelle, who I talked about before, from Maruya, who's worked quite closely with Sue Cutmore, you can see on the screen, our Aboriginal worker, on a grandparents post-separation group that will start at Aboriginal Building Connection and provide further sessions for strategies around specifically working with around separation in the Aboriginal context. So these are things that through these workshops we quite often refer parents to go and talk to the school counsellors about any issues that they have around their children as well. So when we're talking about Aboriginal connections and thinking about from your perspective as in schools, it's really about looking at the whole family in relation to kinship. So, you know, mum, dad, auntie, uncle. You know, we look at the connections for the children, how each connection supports the child. Talk about two worlds that parents and children walk in. So that clash of cultures that can happen with Aboriginal culture and non-Aboriginal culture. So law as in L-O-R-E versus law, the family law. Those challenges that can come up and switching between the cultures and how it can be quite challenging for families if one parent is an Aboriginal family parent and the other is a non-Aboriginal parent. So they're just sort of things that to think about when you're working with your children about the complex nature of families in the Aboriginal community, where, you know, that law versus law. Another thing that we do is the Koori Kids Outreach, facilitated by Nerida and Daryl. It's a child-focused play therapy for healing trauma, loss and grief. They also do family therapy and consultation, and Daryl does some mentoring. They currently go to Jervis Bay School and Culburra School, and referrals are made by teachers and Aboriginal education officers, medical centre elders in the community. And just to finish off, because there's so much I could tell you, Daryl and Nerida recently attended the Snake Conference in Cairns and did a presentation on a report on a child that they had been working with for a few years. And it's really about a new way of thinking and working with Aboriginal children and families. It's about building respect and relationship. And when you build that respect and that relationship, you are more likely to be able to have those connections. One of the other things I think from a school perspective is the learning plans that the schools have are actually a really great way of documenting and becoming aware for the teachers of who the family is, who the connections are, and how they can support the children. So, you know, knowing about the Aboriginal family, who they are, can support these children and families during time of separation. And I think I've run out of time.
Oh, okay. Thanks, Michelle.
Thank you. Thanks for that. That was good.
Sorry. Just due to a couple of last-minute changes, I've jumped ahead a bit too fast and need to go back to Greg's hand. Just going back to some of the things that Carolyn was mentioning about child wellbeing. Greg, did you have anything to add there?
Yeah, thanks, Karen. Look, just to follow on from what Carolyn talked about and what a valuable resource that Family Relationship Centre is for schools, of course, to be aware of, to make referrals to Jenny and the Relationship Centre. Of course, people in schools be aware we've got school counsellors in all schools. Our school counsellors, and the majority are registered psychologists. All of them, of course, have got qualifications in educational psychology. The school counsellor role is really to look at, of course, what's the best thing we can do to support kids to function as well as they can at school. And clearly, during family situations of family separation, we've got to be mindful, and John's been talking about this, about the best interests of the children and make sure that they're functioning. School, of course, can be a really important, stable place for children. Their day-to-day contact with their classroom teacher is really crucial to their development, and it's the place where things can maintain stable and safe and a comfortable place for them to be. School counsellor's role, as I said before, is to really assist with how children can function as well as they can at school. So I have to be really careful in family separation situations because sometimes one or both parents really are urging for the school counsellor to talk to their child. We have to maintain the focus of child's functioning at school, and if the child's going well at school, we wouldn't want to disrupt that in any way. So if school counsellor would talk with the principal, the teacher, and if the child's going well at school, there'd be no reason for a school counsellor to intervene. School counsellor's training is in relation to school-related matters, not in relation to family and separation matters. That's really where Jenny's expertise is, and the staff at the Family Relationship Centre. So it's really important to maintain that clear distinction for a school counsellor, because they don't want to get involved in something they don't have training in, and also something that's not going to be helpful for the child. So the school counsellor will do that in consultation with the principal and the teacher, and really look at how the child's going and see if there's anything that's impacting on them at school. If not, we would leave them, of course, to go about their daily business of schooling, and would then can refer to the Family Relationship Centre. So, that's the important role that school counsellors play, and I think schools, of course, play a really important role in making sure that kids are safe and happy and continue on with their learning. All right, thank you, Karen.
Thanks, Greg. And one of the goals of this project has been about trying to push parents into the appropriate place. So the appropriate place for counselling, for any conflict, any changeover, anything like that. There are services that exist to do that. So where it's happening inappropriately at schools, we just want you to be aware that these services are around that can be referred to. So thanks very much for that info. So we'd like to really consolidate a lot of the information we've provided so far into a couple of case studies. So to assist with that, we've prepared a simple one-page flowchart to help you to navigate the rather cumbersome DEC guidelines. So I'll hand you over to John Littrich from the University of Wollongong to tell us some more and walk us through some real-life scenarios. And don't forget that you can ask any questions via chat. Thanks, John.
Yep, sorry, I was trying to find the spot there. Here we go. Right. Hi, everyone. And thank you, Carolyn, Michelle and Greg for that input. It was nice to hear some different voices starting things off today as well, rather than my voice. But we've also got Wayne on the line, of course, up there as Legal Services branch in Sydney. And by all means, Wayne, if there's anything I talk about in these case studies that you want to have some input on, don't hold back. But yeah, just as Karen, just to recap, back in webinar 1, you might remember we looked at some key legal principles. We looked at some key terms that you might come across from the Family Law Act, and we looked at types of orders that you might come across in your school, parenting orders, apprehended domestic violence orders, those sorts of things. But in webinar 2, we looked at what the DEC guidelines and the law might say about certain situations, such as enrolment, who can get information, who can or can't enrol, pick up and drop off of children, that sort of thing. And we also looked at the role of contact services and also the Family Relationship Centre, where parents can't agree about these issues. And of course, Carolyn and Greg and Michelle have all expanded on that a bit today. So as far as my role today, I'm going to talk a bit about a couple of case studies, as Karen said, and also look at a fact sheet or a help sheet, or a flow chart that we've developed based on the DEC guidelines by way of a resource that might give you some help. And this next slide that I'm showing here is just a JPEG, a photograph copy of the document, so it's a little bit blurry, but there's a web link to the document. I think it's called in the title, it's called a flow chart, and it was one of the documents that you got the web link to earlier in the webinar. And you're welcome to bring that up and have a look at it. But essentially what it is just simply when you are faced with a situation where there's a family law issue at the school, you'll be asking yourself first up, look, are there any legal orders? Is there some documentation of a legal nature in place that governs this situation so we know where we all stand? And if there are, on the left, the chart simply identifies types of orders you might come across. Parenting orders, dealing with who the child lives with, spends time with, and parental responsibility, and refers you to a part in the guidelines that deals with where those orders arise and what the implications of that are. It talks about checking what the orders actually say, whether they're interim, whether they're up to date, whether they're stamped by the court, etc., and then the consequences if they're breached, what you might have to do. It talks about recovery orders. That's an order that usually a third party, such as the police, might be turning up at the school with a copy of to try and facilitate the recovery or the return of a child back to a parent. A location order, which might be served on a school, requiring the school to provide certain information. And then an apprehended domestic violence order, what that's all about, what you might have to be aware of in relation to it in terms of the restraints it might place on the behaviour of one of the parents, and what you might have to do if you perceive that there's a breach of that order. Over on the right-hand side, we look at some of the considerations that come into play where there are no orders or no documentation in place. First of all, there might not be any orders, but it might be a parenting plan or agreement. And as we spoke in one of the previous webinars, there's a big difference between an order and a parenting plan or agreement. An order is something that's enforceable, it's been made by a court, whereas a plan or agreement is something the parents have come to draft up themselves and agree upon. It doesn't have the enforceability of an order, but it reflects what their agreed arrangements are. It may be something they've not nutted out at a family relationship centre, but if it is meant to represent an agreement reached between the parents, it should have both their signatures on it, and it should be dated so you get an idea as to when it was made. So check what the agreement provides for, and basically, if that's what the parents have told, it's been signed by both, they're saying that's what the arrangements are, then you keep that on file, and that's how the school's expected to act until they hear otherwise. And it also says if that agreement is breached, what the consequences are, and again suggests that referring parents to the family relationship centre to try and resolve the issue rather than try and use the school is the way to go. The school's not the place for resolving those issues. And then below that box, there's a box which deals with issues that might come into play when there's no written documents at all. But the default position or the presumption is that both parents, unless it's an order to the contrary, share parental responsibility. In other words, they both have a say in relation to issues and are entitled to participate in activities. They both are able to access documents, etc. And what to do if there's a dispute in relation to areas where you don't have any documentation to fall back on. And again, it suggests that if there's any situation where someone's acting violent or abusive or aggressive, you can ask them to remove themselves. If they don't, remove themselves from the school grounds and call the police. And indeed, whether it's a family law issue or not, you're probably all aware as principals and key staff that under the Enclosed Lands Protection Act, which is New South Wales legislation, anyone who enters school grounds who is asked to leave and doesn't, you're entitled to call the police if they don't, and they can be charged with an offence under that act. So, if you feel the safety of your staff or students are threatened and someone's behaving in that way, you're within your rights, whether it's a family law issue or not, to ask them to get off the grounds. Okay, so that little chart, that little sheet is going to be released to you in a, well, it already has a web link to it now, but along with a parenting arrangement document, which Karen's going to talk about later, and also a referral sheet, which we haven't quite finished yet, but will be released to all participants very shortly. And hopefully you can get some use out of that. It's all based on the guidelines that can be found on the DEC website. So, bearing that in mind and the parts of the guidelines that apply, we'll look at these couple of scenarios that I've taken really from the guidelines. I've just adapted them a bit. Okay, the first set of facts. Let's say you've got two parents who have separated There's court orders providing that the child sees the father on weekends and during school holidays. Father comes to school during the day one day, seeks to remove the child to take the child to a medical appointment. The principal's aware that there's some animosity between the parents, but there's no suggestion of violence on this particular day or no suggestion of a history of violence, and there's no suggestion that the child's not comfortable with going with the father. Well, what do you do? So I won't get to see a race to all of you to jump on your computers and type an answer. There's no class participation mark. Maybe we should have done that, actually, as a requirement. But, so have a think about what you do. Well, I suppose there's a couple of things to consider. Firstly, what does the law require, and what are the DEC guidelines require? And briefly, in that sort of a scenario, you've got the law. Under the law, you want to check, well, what do the orders say? What does this legal document require me to do? The facts told us that there are some orders in place. That document should have been lodged with the school, and you have reference to that, see what the orders say. If the father is indeed limited to weekends and holidays, then unless he's there during that time to collect the child, technically he's in breach of the order. So in the absence of an agreement from the mother, if he's to collect the child outside of that time, he's in breach of the order if he takes the child. Now that breach is not a criminal offence, but nonetheless there may be potential, depending on the circumstances, for risk to the child or harm or upset to the child. Now, the DEC guidelines, taking that position at law, they say in Part 11 that the principal in that situation should attempt to contact the mother first, just check if it is in fact approved for the child to go with the father on that medical appointment. If the principal can't contact the mother or there is no approval, then the guidelines suggest that the father's request should be denied, and the parents should be told to really go away and resolve this matter away from the school, because the school can't be the adjudicators on such an issue. And really that guideline is spot on in terms of the legal requirements, and also errs on the side of protection of the child in case the child could come to some harm. Now, if in that situation the father insists on taking the child, and this is taking the scenario a bit further, in fact, you may well come across the father already walking out of the school grounds with the child. Well, the guidelines and the law also would suggest that the principal's within their rights, certainly, and should try to persuade the father not to persist in that course of action, and should also call the mother to let the mother know what's going on. If the father insists on the conduct, he should be asked to leave, or the police will be called. If he refuses to leave, then, as the guidelines suggest, the wise course is probably to call the police. Now, it may well be that the child's in no danger at all, but you're certainly entitled to do so and to err on the side of caution. Whether the order's breached or not, when anyone turns up, as I said earlier, who gets abusive or aggressive, or there's otherwise a concern for their safety of a child or staff member, don't ever try to restrain someone physically. By all means, call the police in that situation. Now, hopefully the situation wouldn't escalate to that and can be resolved with saying, look, sorry, without permission from the mum, the orders say that the child's only be with you on these certain times and we can't release the child to you. And hopefully dad goes away and sorts it out with mum, so there's no disagreement next time. But that's what the guidelines say. And again, having that, knowing that, or familiarising yourself with the guidelines and making sure you are familiar with what the actual documentation around the child's arrangements says will put you in good stead. Okay, second scenario. In this scenario, the mother, the child at the school provides the school with a copy of a parenting plan. So we're not talking about an order now, we're talking about a parenting plan, which shows that parents agree that the child lives with her, with the child to spend certain times with the father. The plan doesn't limit parental responsibility. In other words, they haven't said only mum can make decisions about these things or what have you. It doesn't limit it. So the default position in that situation, of course, is, as we all remember from the previous couple of slides, is that the presumption is they both have a say in those sorts of issues if they're not limited. Now, the mother also advises, but hasn't provided a copy to the school, of an ADVO, an apprehended domestic violence order against the father. The father advises the school that he's coming to a school speech night at which the mother will be present. She says he can't come because of the ADVO. So what does the principal tell the father in that situation? Well, I'm glad to ask, because hopefully this is the answer. Under the law, as we know, the parenting plan is not an order but represents the agreed arrangements. Unless limited by an order or agreement, both parents are entitled to equal information joining in school activities and so on. The ADVO, on the other hand, is an order. It's criminal in nature, so a breach can be a very serious criminal offence. So whether the proposed breach by Dad or not to the school is in breach of the order, so the proposed visit is in breach of the order or not, will really depend on what the order says. So it's crucial that you get a look at the order. So the guidelines too say at Part 15, if the apprehended domestic violence order prevents the father coming to the school, either specifically to the school or because it prevents him coming near the child or the parent who's at the school, then the father should be refused permission to attend. So as I said, really the principal in that situation, bearing in mind what the guidelines say and what the law says, he really needs to make sure that if mum's saying Dad can't come because there's an ADVO, that mum gives him a copy of that ADVO. He needs to know what it says. He or she, the principal, needs to know what it says. If the apprehended domestic violence order says the father can't approach the school, or if the visit will bring him in close contact or proximity with the child or other parent contrary to what it says in the ADVO, for example, the order might say not to come within 100 metres of the mother or something like that, then the father should be advised he can't attend. If the ADVO doesn't prevent an approach or proximity to the child or the mother, then he can be advised that he can attend provided he complies with all other terms of the order. So if the order is simply one which says don't assault, molest, harass, don't intimidate, don't stalk, those sorts of things, and doesn't make him keep a particular distance or not approach, then there's no reason why he couldn't attend provided that the other terms of the order were not breached. So this is why it's crucial for the school to have a copy of the orders. Wayne, just on those two scenarios, is there anything else you think I might have missed out or you'd like to add?
No, you've covered it very well, John.
Okay, thank you. So just two scenarios. Look, I haven't. There's numerous of those in the guidelines, and if you haven't already, I suggest you have a look when you get a chance at the guidelines, because some very useful scenarios that cover a whole range of situations, and that's just two of them that I've adapted that might be useful for you. Karen I think I'm going to throw back to you just to talk about, I've already mentioned it, about the resources we're going to make available.
Yeah, thanks, John. Yeah, I was just running to that. So another resource that we developed, and this came out of the research that we did in the early part of the project that the university students did. We did a lot of surveying and consulting with the schools to find out what types of problems are reoccurring, and we wanted this webinar series to be practical and offer some helpful tools as well. So we've come up with a few resources. One of them is called, we're just at the moment anyway, calling it the Agreed Education Arrangements Form. If you have a look in your chat box, it's the last item there, and if you click on it, fingers crossed, we should get up on your screen a look at the document, which is just in draft form. The idea behind it was developed by the Family Relationship Centre. Sorry, I'm not getting it on my screen. It was developed by the Family Relationship Centre as something that might be useful for them to use, but also for schools to use as well. The idea being that not all parents actually have formal agreements in place. In fact, most of the problematic parents at schools will actually not have anything in place. So what we heard you say was that it would be useful to have some sort of document on file which captured all the basic information that keeps coming up. So I've got Carolyn from the FRC sitting with me at the moment, so I might just get her to walk through just briefly that form.
Okay, so with this form, this will be something that we will be encouraging parents of school-aged children to bring into the mediation and to discuss. The first part is fairly explanatory. What type of agreement do they have? The second part really gets parents to be thinking about, well, how a changeover is going to occur. Some parents, as we talked about before, will use school as the changeover point so that they don't actually have to come into contact with each other. So it may be, particularly for smaller children, they might have a big bag that has to be, kept in the classroom or kept in the office. So we'll be talking to them about what are the practicalities of a school having to have responsibility for, how many kids, bags, and what's the practical arrangements for that. The other thing that we come across a lot in mediations is who pays the fees, who does the enrolment, reports, newsletters, excursions, all that formal correspondence, and other letters that come home from school. Mine usually involve knits personally. But, you know, what we hear with parents a lot is around excursions. So if children are doing a week about arrangement, an excursion note will come home 1 week, and then they'll argue about, well, who pays for that? The excursion's in your week, you should pay for it. That parent will say, I didn't even know it was on, I didn't get the note. So it's making sure that children aren't left as the messengers, not just between school and home, but school and to home. So we're really going to be talking to parents about getting the nitty-gritty of those things worked out. Who's going to receive them? How will they be received? How will you let the school know that that has to happen? The second page will be about who attends parent-teacher interviews, who receives the absent notifications, particularly now with some schools using text to let parents know when their children aren't present at school. School portals, who will get access to that. And then it's just information about who has provided the information, their relationship to the child, and the fact that the form requires 2 signatures, because again, you don't want just one parent filling out what they would like to happen, or maybe the other parent gets a copy of the form as well and they fill out what they would like to happen. We want to know that it's agreement that the parents have worked out themselves. The 2 ways that I mean, Wayne and Greg, John, you might have different ideas about this, but this form could be given out by schools to parents at enrolment, or to ask the parents to fill it out and bring it back to the school. And as I said, at the Family Relationship Centre, we'll certainly be encouraging our parents to be doing this in mediation. That's all.
Oh, yeah. Okay. Yeah, no, thanks, Caroline. That's excellent. So we're really interested in what you think about that form. Just to put you on the spot, we'd just like to ask you a question about whether you think a form like that might be useful. If it's available to you, would you use it in your school? And while you're answering that question, I will briefly tell you about the third and final resource that we're putting together for you. 100%, that's good.
2 out of 2.
The other thing we're putting together for you is a directory of local services. So it's not going to be a huge directory. We've contextualised it just for schools. So it will contain some of the information you've heard about us speaking about, like the changeover services we talked about last week, where they are, what they do, the child counselling, therapeutic services that the welfare staff might be interested in, and where they are locally. So that will be available in the next few weeks. I have a slide coming up which dot points to those 3 resources, but what we're planning on doing is perhaps combining those resources together, the flow chart, the arrangements form we've just been looking at, the directory, and packaging that up perhaps with a fact sheet for the FRC and getting that out to the schools in the next few weeks as a complete package of information, along with the hyperlinks so that you can watch, or your colleagues can watch, any of the missed webinars as part of this series. And hopefully we'll get that out through the internal Department of Education Regional Office to you. The intention for us with this project was to open up referral pathways between the schools and those services in the area, and also to help link you into our ongoing professional development program around family law. So we really see this final webinar as being the beginning of the next stage as an ongoing process with you. So I think I'll throw that over to John now to do a bit of a wrap-up, and then we've got some time for some questions.
Yeah, I'll be brief, and I can see just looking at who's online today that I think there was some problem with the Department of Education with emails and stuff today. So unfortunately our numbers are down, and whether that means I can bug the uni for funding to do this again, or whether simply they look at the recording. But you know, it's something certainly we'd certainly, when you do your evaluation, you know, we'd really appreciate any feedback as to whether there's issues we could perhaps convince the powers that be to get funding to do perhaps even some further webinar presentations around the issues that we've raised over the last 3 weeks. But thanks for those who've struggled through the technology hassles and have hung in there today, so we appreciate it. So just a real quick wrap-up. You might remember that back in webinar 1 we looked at key principles in the Act, the best interest of the child being paramount, child's rights, not parents' rights, as the focus. The children should have a meaningful relationship with both parents, but this is subject to the best interests and protection of the child, which must have priority. There's an automatic presumption of equal shared parental responsibility, but not, as many people mistakenly believe, 50-50 time. That's really a matter that the parties need to agree on or the court will impose. There's strong emphasis in the family law system on resolution without the court, and indeed the Family Relationship Centre plays a huge role in that regard. Only a very small amount of matters actually end up in court. We looked at some terminology. We looked at that you might see in orders as well. We looked at live with, spend time with. That's parental responsibility. There's no longer custody and access in the documentation. Parenting orders will be either made by the court or maybe made after a hearing or maybe made by consent by the court. They'll indicate who the child lives with, who they spend time with. They'll allocate parental responsibility, not professional, but parental responsibility. The order should be sealed, stamped and dated. So if someone's clutching a document they're showing you that doesn't have any formal indication that it's been sealed or stamped by a court or have a date on it, then you need to ask them if they've got something that does indicate that it has been made by the court. Parenting plans, it's an agreement of the parties. They're not enforceable. They certainly are evidence of the agreement, and the school can rely upon that documentation as to what the parents have agreed. But just check, if it's not signed by both parties, then any sort of agreement is probably not valid. It may well just be a draft that they've one side prepared or their lawyer might have prepared. Other important orders you might come across under state law, ADVOs, apprehended domestic violence orders. They may limit a parent's ability to approach the school or a child. Care orders you might come across, made by Family and Community Services, formerly DOCS, may exist which place a child under the care of someone else, that child having been found to be a child in need of care. One thing that's come through the webinars is the crucial need for schools to know the parenting arrangements and have copies of any documents, orders, arrangements, what have you, and ensure that those relevant docs are provided as far as possible on enrolment, and also the parents are reminded of their obligation to advise of any change to those arrangements. The principal's actions will be guided by what the orders or arrangements say, the law and the DEC guidelines, the educational best interests of the child, the safety of the child and staff, and the efficient and effective operation of the school. Another theme that's come through is that school is not a place for the resolution of disputes, and if a school requires advice, we know we've heard from DEC legal branch, and also we've heard that the resources such as the legal issues bulletins are often useful as well for schools. We've heard a bit today about the role of school counsellors, and also about the services that are available and issues that might arise when we're talking about Indigenous children and families. And we've also heard about various referral services, and as Karen said, we hope to provide you with that written resource which indicates more resources that are available in your area. So they're the things we've covered. In some ways I feel we've covered a lot, but in other ways I feel we've only scratched the surface. So I suppose I'm throwing back to people now for any questions before I leave Karen to say goodbye and wrap us up. Any questions?
No questions so far. Last chance for questions. No? Okay, all right. Well, I've put my email address in the chat box. If anyone wants to follow up with anything that they've heard or contact information from any of the presenters, just let me know. And thank you everyone for your participation in all three webinars. Thank you to our presenters from the Department of Education and Communities, Greg Han and Wayne Freakley, and to today's guest presenters, Carolyn Bateman and Michelle Wasaka. We should also acknowledge the hard work from the University of Law, the students from the law faculty in providing the important research that informs these webinars. I'd personally like to add a very big thank you to John and Greg, who've worked tirelessly on this project over the last year. I've got emails this morning from John at 1:40 a.m, so he's been putting in an enormous amount of work, and I really do appreciate it.
That's all right. I have no life, Karen. That's all right.
And without him and without the funds from the University of Wollongong, these webinars would not have been possible. Just remind you that a recording of all the 3 webinars will be available for you. So if you've missed any, or if any of your colleagues have missed any, we're more than happy for you to share them for any training purposes as well. So we'll be sending out that information package with link information to be able to review those webinars at any time later on. So finally, just checking, no, there's no questions. So if you wouldn't mind, we'll ask you to just answer 4 evaluation questions that are about to come up on your screen. These relate to the whole webinar series, so we would really need everyone to answer these if you could. They are different to last week's questions, and they'll help us to figure out where we need to go as a network from here with you. So thanks again. Unless any of the other presenters have anything to add, we encourage you to contact Nowra Family Relationship Centre if you'd like to follow up with any referral information. And have a good night. Bye, everyone.
Bye.
Thanks, Karen. Bye.
Thanks, Karen.